Major sparks in the courtroom on Friday after defense attorney Kevin Readington alleges the prosecution was caught on a...
It's the kind of moment that courtroom observers wait years to see. Not a piece of evidence, not a confession, something far more damning: the prosecution caught on a hot mic, allegedly whispering a command while the defendant sobbed. But here's the question that changes everything. What were they trying to silence?
It's like I'm so desperate to get a mental break from taking care of everyone that my mind is trying to make something physically wrong with me.
Defense attorney Kevin Readington alleges the prosecution was caught on a hot mic commenting on Lindsay Clancy crying. That's the allegation. And if true, it's not just unprofessional. It's the kind of breach that could unravel an entire case. Before we go deeper into what the documents actually show, make sure you're subscribed to True Crime Court, because we don't just cover the story, we follow the evidence.
Testimony. Now, my photographer was in the courtroom for all of this. He's the one who shoots the video that you see, whether it be on Law and Crime or literally anywhere else. There's only one camera that's allowed to record video, and it's him. Now, he's been court-ordered. Whether there's a recess, a break, there's a sidebar, he's got to go to the seal. And as soon as a recess is called, he goes to the seal and he has to cut the...
Think of a courtroom microphone that was never supposed to capture what it captured. Not because the equipment failed, but because someone assumed the red light was off. That single moment, frozen in the court's audio feed, now sits at the center of a legal firestorm. The paperwork already knew.
Defense attorney Kevin Readington says he does not want to go to sidebar. He wants it on the record that the prosecution allegedly commented under their breath, "Shut her up," as Lindsay Clancy cried during autopsy testimony.
The transcript reads like a scene from a legal thriller. Defense attorney Kevin Readington, standing before the judge, makes a declaration that shifts the entire atmosphere of the proceeding. He does not want to go to sidebar. He wants it on the record. The prosecution, he says, was caught on a hot mic uttering two words as the autopsy testimony played. Words that, if proven, would constitute something far beyond a simple error in judgment.
At the time. And we've seen a lot happen this past week in court. For instance...
No, I don't want to go to the sidebar. I really don't want to go to the sidebar.
I need to know what you're going to talk about before...
I want to tell you that they got picked up on a hot mic saying, "Shut her up," during the playing of that autopsy.
The exchange is brief. The defense attorney states clearly that the comment was picked up on a hot mic, "Shut her up," during the playing of the autopsy. The judge listens. The courtroom waits. But it's what happened next that turns this from a procedural dispute into a constitutional crisis. A judge who had already drawn a line in the sand delivers a warning that sounds more like a verdict than a caution.
Around.
I just want to make it real clear that there is to be no inappropriate comments or disruptive comments to be made inside of this courtroom. If anybody is found to make those, they will be immediately escorted out and barred for the balance of this. All right, I just want to make that real clear. And just in case you're wondering, there are microphones all around. And so if I get a report of that, there's going to be some serious issues and serious problems. So I just kind of wanted to put that out for everybody so it's crystal clear. There's going to be no warnings, no yellow cards. You're out.
The judge's words are measured, deliberate, and devastating. There is to be no inappropriate comments or disruptive comments to be made inside of this courtroom. If anybody is found to make those, they will be immediately escorted out and barred for the balance of this. He continues, making clear that there will be no warnings, no yellow cards. You're out. The message is unmistakable. Someone crossed a line, and the court intends to hold them accountable.
So we can't say for sure what the Commonwealth said or if it was even the Commonwealth. And to be fair, their faces did look really surprised when the defense made this allegation. It's all speculation at this point. I mean, we don't know exactly who said what, but we do know the judge isn't messing around.
But here's where the story takes its sharpest turn. The DA's office reviews the tape. Their conclusion: it wasn't them. It was someone in the gallery saying, "Shut it off," meaning the camera. The prosecution's faces, were told, looked genuinely surprised when the allegation was made. But in a case defined by its contradictions, one question lingers. Why would anyone in a Massachusetts courtroom, on the day of an autopsy, be concerned about a camera feed and not what it was recording?
The chilling words of child killer Lindsay Clancy front and center at her murder trial.
This is a case where the defendant admits she strangled her 3 children, 5-year-old Kora, 3-year-old Dawson, and 8-month-old Callan, with exercise bands. She does not deny it, but her defense team has argued from the beginning it's not murder. They say Lindsay Clancy was in the grips of postpartum psychosis, a mental break so severe that she lacked criminal responsibility for her actions.
You're familiar with the concept of postpartum psychosis, correct?
Yes.
And you know that people can communicate and plan and act on plans even if they're in the middle of a psychosis, right?
Yes.
You don't have to be drooling and stumbling and unable to walk and talk to be in a psychosis, do you?
No.
So in other words, a person can be in a psychosis and can communicate to friends, family, people, talk, correct?
The prosecution's own witness, a psychiatrist, establishes a critical point. People experiencing psychosis can communicate, plan, and act on those plans. They don't have to be drooling, stumbling, or unable to speak. The implication is devastating for the Commonwealth's narrative. Sound mind and psychosis are not mutually exclusive, and the prosecution's case hinges on proving that distinction beyond a reasonable doubt.
Deaths.
You mentioned that you went to New York in November of 2022. Defense counsel said that was a month before the children were killed, but that's actually 2 months before they were killed, correct?
It was, it was about a little more than 2 months.
Now consider the timeline. Patrick Clancy, the defendant's husband, traveled to New York in November 2022, 2 months before the children were killed. He was asked directly, was that trip for work? He confirmed it was. But the internet, as it does, has drawn a different conclusion. Rumors of an affair have swirled, fueled by photographs of Patrick with his new wife, Dr. Rachel Danis, who lives and works in New York. The timeline is not proof of anything, but it is an unanswered question that won't disappear.
It was, it was about a little more than 2 months.
And so when you took your trip to New York, she was having some issues, but she was doing okay, wasn't she?
She was doing much better than she was in December.
Okay. And did you also take another trip with Kora in November?
Yeah.
The defense seized on this. They asked Patrick T. if Lindsay was having suicidal and homicidal thoughts, why would you leave her alone? Why would you take a trip to New York? Why would you then leave again with Kora to San Diego? The implication is clear. If she was as dangerous as the prosecution claims, why did her husband trust her alone with the children for extended periods? The paperwork already knew.
The day that Lindsay Clancy killed the children, Patrick was sent to CVS to pick up some stool softener for Kora before heading to the 3V restaurant in Plymouth to pick up dinner for him and Lindsay. And here's the security camera video of him inside the CVS. That's where he went first. And you can see Patrick is wearing what appears to be a half zip and then brown boots. When he arrives at the 3V restaurant just a couple minutes later, it appears as though he's wearing different shoes, this time tennis shoes, and a full zip jacket. And people are talking about this. Again, on my same podcast appearance, one person wrote, he wore different shoes and possibly clothes in the surveillance footage at CVS and the restaurant. This same commenter points out her fingerprints weren't found on the murder weapons, which, by the way, is true.
But the bottom line is that you didn't get any fingerprints.
Correct.
And that you could have just said that, right? Just come on the witness stand and say, we didn't get any fingerprints.
Sustained.
But all this together has led...
Then there's the surveillance footage. The day of the killings, Patrick went to CVS. The video shows him wearing a half, zip, and brown boots. Minutes later, at the 3V restaurant, his footwear appears to have changed to tennis shoes, his jacket to a full zip. Did he simply change because his boots got wet from snow? Or is there something more to the story? The Commonwealth's case depends on establishing a narrative of control and intent. But these inconsistencies, however small, feed the public's distrust.
True.
But the bottom line is that you didn't get any fingerprints.
Correct.
And that you could have just said that, right? Just come on the witness stand and say, we didn't get any fingerprints.
Sustained.
But all this together has led some people to ask, I'm wondering if he did it. And I'm not saying that at all. But I am saying there are a lot.
And one more detail, her fingerprints were not found on the murder weapons. The prosecution's own witness confirmed it. They got no fingerprints, which raises a question the defense has been asking since day one: if Lindsay Clancy was so calculating, so meticulous, so in control, Why didn't she leave her prints on the bands she used to kill her children?
The Commonwealth.
And because no one could take care of her kids the way she wanted them to, she had to take them with her.
Is the Commonwealth alleging Lindsay was such a helicopter parent, no one could parent like she could? That's why she left the nanny those intense notes.
The prosecution has painted a picture of a controlling, perfectionist mother who could not let anyone else care for her children the way she did. They point to the detailed notebooks she left for the nanny, meticulous instructions on feeding, sleep schedules, even how to cut vegetables into 1-inch squares. But the nanny herself, when called to testify, did not describe a woman exerting control. She described a loving mother, a good mother, the prosecution's own witness.
Not at all.
Felt that was appropriate for her to tell you about the cutting up of the vegetables and squares and things?
Yes.
The nanny went on to say,
Did you have the occasion to observe her interacting with the children?
I did.
And did you have any concerns about her interacting with the children?
Not at all. She was a wonderful mom.
And at one point, do you recall saying to the trooper, I loved my Lindsay?
I loved my Lindsay.
Yeah.
I don't recall saying that.
Okay, did you?
Do I love Lindsay?
Yeah.
I did love Lindsay, yes.
The nanny was asked, did you find her instructions overbearing? Not at all, she said. She described watching Lindsay with her children and having no concerns. And when asked if she loved Lindsay, the nanny's response was simple and direct. I did love Lindsay. The jury took note, writing in their notebooks. The prosecution's star witness, meant to support their narrative, had just humanized the defendant.
Now, the prosecution is getting a lot of hate for, people are saying they're anti-woman. They say that these are two women going against women, because if anybody should know the mental health struggles that women, I would say most women, not all, but most women have after giving birth, that it should be two women. How they're trying to make it seem so much more vicious than it was.
yeah, it's really hard to separate emotions in this case for people watching it, because all of us have a mother. A lot of us are mothers. We have sympathy for people who are raising kids and going through these mental health struggles. And I do feel like the prosecution is getting a lot of...
The Commonwealth has argued that Lindsay Clancy is not a victim of psychosis, but a woman who carefully planned the deaths of her children, and then, when it didn't go as planned, tried to take her own life. They point to her request for a DNR. They point to her attempt to change her healthcare proxy from her husband to her parents. They argue that her actions in the hospital, writing, "Do I have an attorney?" show a woman aware of the consequences of her actions. But if she was so calculating, why didn't she make sure the job was done? Why is she still alive?
I'm seeing the Court of Public Opinion is saying that the prosecution has no case. That is why they're agreeing to these stipulations that were argued for so heavily in pretrial motions that the Commonwealth would not agree to any stipulations. Well, now that their case isn't going as well as they thought it would be a slam dunk, that this would just be a cut and dry case, that Kevin Readington is showing all of these, amazing sides of Lindsay. We're getting some great testimony that she was a wonderful mother, that people are saying the prosecution is not doing well and that the defense is doing a very good job.
The Court of Public Opinion has reached a different conclusion. The prosecution, they say, has no case. They point to the fact that the Commonwealth resisted pre-trial stipulations, but is now agreeing to them. A sign, they argue, that the case isn't going as planned. Defense attorney Kevin Readington, they say, has been masterful, painting Lindsay as a victim of medical malpractice, a mother whose pleas for help went unheard until it was too late.
In the case, we're still in the Commonwealth case at the time of this recording, so there's still a lot of head. I mean, this weekend I was hanging out with friends and they were saying, if something happened, I would hire Kevin Readington. I mean, he's putting on an amazing defense, and the prosecution has a lot of evidence and witnesses too. So I guess we're gonna have to wait and see. It's really up to the jury in the end, but
the prosecution still has time to present its case. The jury still has to deliberate. But the hot mic moment, whatever it actually captured, has become the symbol of this trial's central question. Can the Commonwealth prove intent beyond a reasonable doubt when even their own witnesses call her a wonderful mother, when the timeline of the husband's actions invites skepticism, and when the system that was supposed to protect her may have failed her? The paperwork already knew.
wow, we've covered a lot in this episode, and we'll be back next week for even more. Make sure to stick with Law and Crime as we're live streaming the entire Lindsay Clancy trial gavel to gavel, giving you front row courtroom access. And that is where today's
We're still early in the proceedings. The Commonwealth's case is still being presented. But here's the question we're asking, and we want you to decide. The judge's warning, the hot mic allegation, the shifting narratives, all of this exists in the public record. But the one document that could settle it is the sealed transcript of what was actually said. Should the court release the full audio? Let us know what you think in the comments. If you found this breakdown valuable, like, share, subscribe, and turn on notifications for True Crime Court. Because the most powerful evidence is often the one the system tries to bury.